The commercial division was established after those in the industry approached the judiciary. Those doing business, they felt that it took too long for their cases to come to trial. And because of the amount of time that each of the cases took before they were resolved, they were held in limbo. So that if you put in your investment and somebody had a dispute with you, first, your money was stuck, and secondly, you don't know whether you're going to go on or not.
So the Commercial and Tax Division was established with two main objectives. One of the objectives was that it needed to make litigation faster, fairer, and more accessible to the business community. The other objective was to enhance foreign investment by fostering investor confidence.
Dispute resolution is at the center of any judicial system and at the center of business. Businesses want to know that if any dispute arises in the course of doing business, that it would be adjudicated fairly and in a timely manner, because for them that gives them comfort that they can get into business transactions.
Some things are expected from the judiciary, others are expected from other people, ranging from how quickly you can form a company, register a business, buy land, and so on. But the judiciary ultimately is the home at which any disputes are resolved. So we have our role. How quickly do we resolve disputes arising from contracts?
Under the Commercial Justice Sector Reform Project, the object is to assist the judiciary and to empower the judiciary to, within initially in the commercial division of the court, to be able to provide services on an online basis, to be able to provide for e-filing so that litigants are able to file their cases online without having to come physically to the courts. It is aimed at increasing the efficiency, and we are piloting this initially in the commercial.
E-filing has about 4 main stages that it goes through. The first stage is the filing by the client. Then the second stage is the adoption by the judiciary and e-service to the respondents. Then the third step is to respond digitally on the system. And the final stage is now a continuous cycle of filings and respondents.
Is a case in Milimani High Court within the Commercial and Tax Division, and it's a HCCOM case.
The Deputy Registrar requests certain law firms that are able to file under the e-filing system. And what happens is that these firms are opened for accounts under the case management system, the whole system, which they are able to log in from the comfort of their offices. From the offices, they are able to upload all documents that are necessary for filing of a suit. And once they upload the documents, the system automatically calculates the amount that they are supposed to pay for their case. Once the money is calculated, how much they're supposed to pay, it's then they are able to pay through the mobile platform, which is M-Pesa. Once they pay, the system again, the cashier is notified via SMS that this amount has been paid for this case number, and indicating the parties, and also the lawyer is informed via SMS. Thereafter, then the system automatically allocates a case number, and then the case is deemed to have been filed under the e-filing system.
The e-filing, now you just sit in the comfort of your office and you file your case. What will that then mean? It will mean that you do not have to come to the registry to retrieve your file. You can always retrieve it. It's online, it is an e-file. It's a game changer for us, let's say. And it's a trajectory. We are excited about the journey ahead of us.
We are hoping going forward that the service of the pleadings will also be done electronically, except for the first one. Because if I am suing somebody, I may not necessarily have knowledge of their email at which to serve them. But it is a requirement that once you are served, when you are filing your response, you give your email address, so that thereafter the parties can exchange documents electronically. That too will enhance efficiency to a great extent. How do you clear the backlog whilst sustaining the rate, a good rate of clearance of current cases? The judiciary, in consultation with other stakeholders, came to the conclusion that mediation is one of the factors that will help all of us fight the backlog. Mediation is a system where parties who are already before court are told that your case has been referred to mediation.
We've been working a lot with the commercial division as the Kenya Association of Manufacturers, just to see how we can improve access to justice through the commercial division. And one of the things we've seen that is positive is the introduction of court-annexed mediation.
It is an instance where cases which have already been registered in court do not go through the adversarial process, which is the ordinary process of cases that have been presented in court, and instead our parties are given a third party who is not a magistrate or a judge, and the role of this party is to mediate as between the parties. So the role of the mediator is purely to bring the parties into a discussion, enable them discuss the issues and the reason why they have the dispute in court, and then attempt to have the parties reach settlement. In the event that the parties reach settlement, then the mediation settlement agreement is adopted in court as an order and enforced in any other manner like the other judgments or orders that have been issued in court. In the event that the parties do not reach settlement, then the matters are referred back to the adversarial process, and we go ahead with the case management like the other cases which have not been referred to mediation.
The uptake may not have been as much as it could be for various reasons. One of them is the understanding of business on what mediation is and why it is a better alternative sometimes to resolve disputes. The second one is the capacity of the institutions to be able to understand mediation or play a role in it. There is also the issue sometimes that the advocates would prefer that you go through a full judicial process, which is typically what we've done in the country. So like anything new, it has had its teething issues. As the Association of Manufacturers, we are now at the forefront of building capacity on mediation. We are currently running a project in partnership with the GIZ on mediation at CAM, so that we start building the capacity of manufacturers to understand the issue of mediation and how it's beneficial to their business.
Between the pilot project and a report which was prepared as at 3rd of May, we had referred a total of 629 matters to mediation. So out of these 629 matters, 353 have been concluded. And out of the 353 that have been concluded, 195 have full settlement agreements. So there are cases where there is no dispute that is still being referred back to court for examination through the adversarial process.
Court users committees are a feature of the judiciary. It brings together the judges or magistrates with the people who use their courts. The Commercial and Tax Division had a unique situation because most of the cases that come to court are brought by lawyers on behalf of their clients, corporates mostly. So we formed the Business Court Users Committees.
The BCUC is comprised of membership from the judiciary, that's the commercial division of the High Court, and the business community. So the business community is represented through representative business membership organizations. So we have Kenya Association of Manufacturers on board, the Petroleum Institute of Africa, the Kenya Bankers Association, we have KIPI, the Kenya Intellectual Property Institute, and KEKOBO that deals with copyrights. The Retail Trade Association of Kenya is also a member of the BCUC. And it's open to all other business membership organizations in the country who can come on board to represent the specific interests of the area of business that they represent. The first thing it's been able to do, it's created a platform where we can come together to discuss issues around commercial justice. And this platform has been very useful over the last 2 years. We've been able to come up with ideas on how we can improve a lot of things within the commercial division.
The outcomes of the Business Court Users Committee is the Commercial Guidebook, working together with the Kenya Magistrates and Judges Association and the Kenya Association of Manufacturers. We brought together teams which answered a lot of the questions. What is court fees? What is costs? We answered such questions. Of course, we brought together Kenya Revenue Authority, Kenya Bureau of Standards, KIPI, and the likes. So those are fruits that we are beginning to see of working together between the judiciary and the business community.
Right now, we are piloting this at the commercial division. But the manner in which the system has, the architecture of the system is designed in such a way that it will easily roll out to the rest of the country. So that the modules that are being developed are modules that can accommodate the entire judiciary. So once we have run it in the commercial division, we intend to roll it out to the rest of the country and to the rest of the courts.
One of the things we would like to see going forward is to see the BCUC replicated around the country. The Kenya Association of Manufacturers has 7 regional offices representing different parts of the country. It would be important going forward, once the Nairobi BCUC is up and running fully, to have the same replicated in other stations like Mombasa, Kisumu, Nakuru, Eldoret, Machakos, where we have a lot of business presence.
We are still manual in our proceedings. You know, recording the proceedings, recording the evidence of a witness you take a whole day sometimes hearing the evidence of one witness. So if we can digitize, first of all, and have all our records in electronic files, that will guarantee the integrity of the court record. If we automate our proceedings, we will hear, I am certain, we will be able to dispose of more than twice the number of cases we are disposing of now, and we will move on. There will be no issue of evidence given by a witness which has not been correctly recorded, and that kind of thing, and we will be able to move on.